I come home from work and find my wife in bed with another man. I shoot her. My extreme emotional disturbance is an aggravating factor, simple misdemeanor to DV misdemeanor in this assault. Why?
All right, so we're the Armed Attorneys. We're going to be talking about a whole bunch of fun things today. These are your questions answered. We're going to be talking about, should you keep a log of all your firearms? What happens if you discover an unfaithful spouse? And how does sudden passion apply in a criminal case? And are juries kind of boxed in when they're given instructions on the law? Think about a jury instruction. We're going to be talking about all that and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And I want to start this off with just a quick discussion about Charlie Kirk. We film these videos, especially now that Emily's out on maternity leave. We have to kind of plan these videos out further in advance than we would like. And so this is our first time recording since he was assassinated. Obviously, we put up a note in our community about it. Obviously, this was a humongous tragedy, but we did want to say something about it.
Yeah, very, very sad for him and his family. I just can't imagine his 2 little kids and his wife. It's such a sad time for our nation.
Yeah, and I was reflecting on it. I mean, I'm just like everybody else. We all had thoughts on this, and something that I think is worth pointing out. And I don't know that it's going to get airtime like a lot of his other clips are on social media right now. There's some really great ones going around. But if you watch him, because I watched Charlie quite a bit, he would insert the phrase, feel free to disagree. He said that so many times I couldn't even count them. I was going back through some old videos. And I think that's worth, I think it hit a lot of folks who kind of talk to y'all a lot, because I would put him up there with a lot of other civil rights activists with the First Amendment. Nobody wants to see the First Amendment get shot. And so, I think talking, even if you disagree, very, very important. But we're not going to stop talking to you about self-defense, firearms, Second Amendment, trying to make life for the law-abiding gun owner just a little bit easier. But we will continue to talk about these issues, even if we disagree.
Yeah, and along that, we have a comment section, and we would love to see some respectful debates happen in the comment section. What we talk about is kind of controversial. People have strong feelings about the Second Amendment one way or another. So, feel free to have those respectful debates in the comment section if you want to.
Yeah, but we're gonna, the show must go on. We're gonna be talking about some gun law, Second Amendment stuff, and we're going to start this off with your questions.
Yep.
These are questions that we get from our comment section. If you want one of your questions answered, type out question. That helps us find these things. If you see somebody else's question you like, make sure to give that a thumbs up. Those things kind of rise to the top, and we'll get those things answered. So let's kick things off first, Leslie, to you. This is from Wrenchhead. Question.
Yeah.
How are jury instructions determined? What is some evidence not allowed in court aside from illegally obtained? It seems like jury instructions predetermine someone's verdict at times rather than the evidence.
Yeah, that is a really great question. I think that's something that a lot of people don't think about and probably don't know about. This is what I do. I try cases all the time, and the jury instruction is so important. So what the jury instruction really is it's the judge's instructions or the charge of the court to the jury. So when the jury goes back to deliberate, they're given, it's typically probably 14, 15, 16, 17. They're long booklet of instructions that the judge has created in order to follow the law. So the judge gives them the law to follow. So it's not like we as the attorneys can get up there and say, hey, here's what the law says, believe us. The judge tells them what the law says. Now, with that said, we do have input as lawyers. So typically what happens is there's actually, I know in Texas, there's a Texas pattern jury charge where a lot of judges will kind of get the basics for a jury charge. And a lot of them say the same things, towards the end. You can only communicate with the bailiff. You can send a note if you have questions. But the actual law, especially in self-defense, gets debated a lot. So a lot of times what happens is that the state will submit what they want as the jury charge, and us as the defense will submit what we want as the jury charge. The judge will look at both of them, and then we'll have to make arguments on, why ours should why our input should be included, or the state will come back and say, oh no, that needs to stay out because of, XYZ. And a lot of times it comes down to case law, having your ducks in a row to make the argument to the judge. And I can also tell you, if the charge of the court is not right, that is one of the quickest ways to get a case overturned, especially here in Texas. So let's say that there was an instruction that should have been included and it wasn't included for some reason. You're probably going to get your case overturned because these jury instructions are so important. Now, the second part of this question, I believe, was about why some evidence is allowed or not. And that goes to the rules of evidence. So, here in Texas, we have the rules of evidence. So there's certain things that can come in and there's certain things that can't. And it's interesting, preparing for trial with a client, they'll bring you this whole list of things that they're like, yeah, let's put this on. Let's put this on. Let's talk about the fact that, when this guy was 5 years old, he got in trouble. That stuff doesn't get to come in a lot of times, unfortunately, because the rules of evidence. And in Texas, we have a bifurcated trial system. So we have a guilt innocence phase, and then we have a punishment phase. So the guilt innocence phase is essentially like if you took a photo album, you take one picture out, and all you're allowed to talk about during that guilt innocence phase is that one photo. You're talking about the incident that occurred, that moment, what led up to it, what didn't lead up to it. And that's what you're allowed to talk about. And then if you make it to a punishment phase, which means that the defendant was found guilty and is now facing a punishment. If you get to that phase, now you kind of get to see the whole photo album. So now there's a lot more we can talk about. But the rules of evidence is what determines what evidence can come in and what evidence can't. The other thing is you have to be able to authenticate all of your evidence. So if you have something and we're not able to prove where it came from or how it came from, or the state, really the state is the one who puts on majority of the evidence because they have the burden of proof. They have to prove that the person is guilty. We don't have to prove that the person is innocent. So, let's say that the state has a piece of evidence that they're trying to get in and they can't authenticate it. That's the easiest way to keep something out is by going up and saying, well, we don't know where this came from, Judge. We have no idea who took this picture or when this picture was taken or how it was taken or if it's been edited or if it hasn't been edited. So that's a really good question. And I think that's something that a lot of people probably don't think about.
Yeah. Is it relevant? Is it authentic? And then, is there some reason, like special government reason why it couldn't come in? Think illegally obtained, think hearsay, think this might confuse a jury. There's a lot of different things or bias the jury. So there's a lot of moving parts there. But yeah, it does feel like sometimes, depending on the instruction, that the jury's only left with one choice to find the person guilty or not guilty, or, if it is a civil case, they're required to give this person money. It just really depends. But those are very important, and that's why it's so important to have an attorney that, especially when it comes to self-defense cases, that understands self-defense, understands how to preserve error, and all the potential instructions out there. Because like Leslie said, there's typical model, jury instructions. You see those floating around. But there are some really special circumstances that, hey, it needs to be brought to the attention of the jury. That's maybe based in common law that isn't in those manuals. And so, yes, these things are very, very important.
It is. Next question, Richard. This one is from at Connor Snook 776. Question: if I am prevented from carrying into a place, is there a criminal negligence statute that places a duty on the place to protect me, but fails to, but not for the location preventing me from carrying? I could have avoided great bodily injury or death.
Yeah, we kind of talked about this or alluded to this in the past. Generally, no. We don't have any state that imposes liability on these premises for, inviting people onto their property, not providing necessary security. And that's because courts have almost uniformly held that criminal actions are intervening causes to, a known danger to the public. Now, we are waiting for the right case with the right facts that say, hey, guess what? You were on notice because you have this duty. You didn't take this corrective action. Damage occurred, and there's that causal nexus between those two things. We're waiting for the right case for that. Don't have it yet, but we have seen some states try to legislate this into existence. Hasn't made it across the finish line. We tried it in Texas. It didn't work, but or hasn't worked yet. There we are. So, but it's something that you should be aware of. All right, next question. This is Lost in Space 8238. What if you stay overnight at a hotel in New York on your journey from Maine to California? It would be negligent to leave the firearm in your car, so you would have the firearm in your hotel room. You may not have ceased your trip. You made a temporary pit stop along the way. Would that be legal? Seems like it would be. So this is in context of the Firearm Owners Protection Act.
Yeah.
Again, this is an affirmative defense to prosecution when someone is traveling through a gun hostile state. And I'll just go over the qualifications and I'm going to pass it off to Leslie. But legal start, legal finish, unloaded, encased and inaccessible, or locked up and in the trunk, and can't cease traveling between your legal start and legal finish. So this is assuming, I think there is a little bit of an assumption built into this question that you could possess the firearm legally in California. But let's just say, argument's sake, legal start, legal finish, unloaded, encased. Yeah, leaving a gun in a car is a bad idea, but is this hotel stop? Is this ceasing traveling?
It probably is. Yeah. There's been cases where less time has been considered ceasing traveling. So, I mean, there's been cases that have said that, stopping to have lunch is ceasing your traveling. Really stopping for any period of time in this hostile state, New York, for example, anything more than potentially, if your tire blows out, could potentially be seen as ceasing travel in the eyes of a court, and actually has been in the past, unfortunately.
Yeah. So really minimizing that. Again, this is an affirmative defense that you could raise in your trial. And if a jury basically gets the instructions, here are the qualifications. Do they meet the qualifications? Ultimately, have you ceased traveling is a question for a jury. The least amount of time, apart from involuntary stops like Leslie was talking about, the better. So you want to be very careful.
Absolutely. This one is from at LDR1100RS, and the question is, I come home from work and find my wife in bed with another man. I shoot her. My extreme emotional disturbance is an aggravating factor, simple misdemeanor to DV misdemeanor in this assault. Why?
All right, so you look at, and this is making some assumptions. So we're going to answer the question that we were given us. We're not talking about defending somebody from an unlawful threat of force or unlawful deadly force. This is just pure sensibilities overwhelmed by, what's in front of the person. All right, now when we see sudden passion, because really that's what is getting at the heart of this question, how does sudden passion interact with criminal charges? Well, unlike self-defense, where it's an affirmative defense that justifies and excuses the conduct, it's a factor that reduces the culpability. Okay, so and where does this come up? It comes up in the punishment of the case. So it's I did it, but please don't, throw me in prison for the rest of my life. Please don't XYZ for the, because here's the reason why. And how does it work in most states? It reduces the degree of the offense typically by one step. So an example, murder, let's say that's punishable by, we'll just use Texas, 5 to 99 years or life in prison. Okay, maybe it takes it down to a second degree felony where the punishment range changes from 2 to 20 years. Or for a misdemeanor where the punishment might be up to a year in jail, maybe it takes it down a degree to where maybe it's only 6 months in jail. So it doesn't excuse or justify the conduct, but maybe it reduces the punishment on the back end because it's a mitigating factor.
Yeah, and I don't think the situation itself is what makes it an aggravating factor in a misdemeanor. And I don't think that's what causes it to go from a simple misdemeanor to a DV misdemeanor, DV meaning domestic violence. Here in Texas, if the assault involves anyone who qualifies as a family member under the Texas statute, which is either a spouse, former spouse, someone that you had a dating relationship with, have a dating relationship with, or a roommate potentially, that is what's going to make it into the family violence assault.
Yeah, it's like a finding. It's not It's not like a different charge. It's a assault charge with a finding of, and that's what you see in most states. And there probably are some states that say, hey, we're going to punish these particular set of individuals differently. But I'd say in the vast majority of states, it's just a finding, just like a deadly weapon finding, just like a sudden passion finding. Maybe it changes the punishment, or maybe it adds some disability upon conviction, like a misdemeanor crime of domestic violence where you might lose your firearms rights or forever, right, under federal law. So typically just a factor. All right, this one for you, Leslie. This is Navy Vet 8810. Question: is it a good idea to keep a written record of all your firearms, or would this cause issues, either police or prosecution, during a self-defense use? Yeah, I actually love this question.
I do too. And I get this one a lot. So someone will call me and say, hey, I lost my firearm. I need to know how to get the serial number so I can report it. Well, I got some bad news for you. Well, actually, it's probably good news for you. No one has a record of that firearm serial number. So the way it works is guns are not registered to you. So there's no gun registry on the federal level. There's no gun registry in Texas. Now, when you're the initial purchaser, so meaning if you buy a firearm from an FFL, a firearms licensed dealer, you're always going to be listed as the initial purchaser. So if they run the serial number on that gun, it's always going to be linked back to you. But let's say that I sell Richard a gun. I bought that gun. It's always going to say that Leslie Cross is the purchaser of that gun. Now, if Richard buys it, we might have a bill of sale showing that he purchased it from me, but that record never changes. So my name doesn't come off of it and his name doesn't go on it. So there's no way to do that. There's no gun registry. So there's no one that tracks that. So you can look up the initial purchaser by looking at the serial number.
Yeah, when they do a firearms trace.
Right. But you can't look up Leslie Cross and see what guns I own, which is something that we fought for. We fought to where we can't be able to do this. So keeping a record for yourself of your firearms and your serial numbers is probably really important.
Yeah, I'd say best practices are, when you purchase a firearm, recording that information, copy of this receipt, maybe a picture of the box, keeping those documents separate from your firearms themselves, keep them in your important documents box, keep them at your office, keep them out of your gun safe, in the event that we don't want these things falling into the hands of law enforcement or anybody for that matter. But the ability to prove ownership, and this is where it comes up most frequently, when a firearm is stolen, and being able to quickly report to the police, hey, this is the gun, because ultimately we want the gun to come back to you, right? You're a victim of a crime, we want to get your property back. That's where I would say it comes up more than 80% of the time when the person's a victim of a crime, being able to prove ownership.
Yeah. And I've never had it come up in a case where someone has said, oh, this person kept a record of their firearms and used it against them. That's not something that I've ever had come up.
Yeah, but really the only way the police would get into the safe, get into those documents, let's say if you kept them all together, most of the time it's going to be consent. These documents aren't going to be relevant if they're executing a search warrant for a particular firearm. They go in there, they see a bunch of documents. They shouldn't be monkeying with that stuff. Obviously, speak to your lawyer should you find that. But I think the advantages way outweigh the disadvantages.
I agree.
But this was a fun bunch of questions.
It was.
We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your questions in the comment section down below. And until next time, we're the Armed Attorneys.